When a marriage ends, the shared financial ecosystem fractures along with it. You are left with a lifetime of asymmetric assets, homes, pensions, businesses, that must be divided without destroying their inherent value in the process. In England and Wales, the ultimate authority for redistributing that wealth is the Matrimonial Causes Act 1973. A common assumption is that the court simply takes a ledger and cuts every asset exactly in half. That is rarely how the law works. Instead, the court operates with vast discretionary power, constrained by a specific legal framework designed to achieve a fair outcome. To understand how this operates in practice, we have to look at the statutory factors the court must consider, the guiding principles of needs and sharing, and the specific mechanical orders used to sever financial ties. Mastering this architecture of discretion is the only way a legal professional can accurately predict outcomes and engineer a robust, workable financial settlement. This matrix represents Section 25 of the Act. It's the statutory checklist courts use to evaluate a family's financial position. At the very top is Section 25(1). The court must give first consideration to the welfare of any minor children of the family. In practice, this means the parent who is the primary caregiver will normally succeed in retaining the family home to house the children, provided the mortgage and outgoings are affordable. Below that, the court evaluates the Section 25(2) factors. It examines the current and future income, earning capacity, and the specific financial needs and obligations of each party. It also accounts for the standard of living, the age of the parties, the duration of the relationship, and the contributions each person made, explicitly including looking after the home and caring for the family. Section 25 guarantees the court takes a complete inventory of the ingredients available for a settlement. But it does not provide the recipe for how to divide them. To translate that inventory into an actual financial division, the courts rely on three jurisprudential principles: sharing, needs, and compensation. The legal starting point is the yardstick of equality, established by the case of White versus White. It sets an initial baseline of a 50-50 split of the matrimonial assets. This yardstick exists to prevent discrimination. It confirms that the financial contributions of the primary earner and the domestic contributions of the homemaker carry equal weight in the eyes of the law. However, a strict mathematical division often fails practically. Spouses frequently leave a marriage with asymmetric earning power or unequal caregiving responsibilities. This leads to the most critical rule of practice: needs will always prevail over sharing. If an equal division does not leave one party with enough capital to meet their basic financial needs, the court will depart from equality. For example, the capital required to rehouse a primary caregiver and the children frequently justifies awarding them significantly more than half of the available assets. The third principle is compensation, designed to address severe economic disparity caused by the marriage, such as one spouse permanently sacrificing a lucrative career to support the family. In reality, compensation arguments are rare. They generally only succeed in high-net-worth pieces where the available resources far exceed the basic needs of both parties. True legal fairness is achieved by elevating survival and housing needs above rigid mathematical parity. Once the court determines what a fair division looks like, it has to physically execute it. It can issue income orders. These range from maintenance pending suit, short-term cash flow while the divorce is finalized, to periodical payments, providing ongoing monthly support. As listed in this breakdown of the module, the court relies heavily on capital orders, specifically under Sections 22 through 24 of the Matrimonial Causes Act. Property adjustment orders under Section 24 allow a judge to physically transfer ownership of an asset, taking the family home out of joint names and placing it solely in the name of one spouse. If neither party can afford to maintain the home, or if the capital tied up inside it is required to rehouse them both, the court can issue an order for sale under Section 24A, forcing the liquidation of the property to free up the equity. Then there are pension orders. Pensions are uniquely complex because they are illiquid future assets, locked away until retirement. The court can mandate pension sharing, which carves out a percentage of the actual fund and transfers it to the other spouse, or pension attachment, which earmarks a portion of the future payout to be diverted at retirement. Because pension values do not map clearly onto cash values, they almost always require a separate actuarial valuation before the court will divide them. These statutory orders, income, capital, and pensions, are the physical levers judges and practitioners pull to bring the Section 25 scale into balance. A core logistical problem remains. You cannot easily slice a house or a pension fund in half without destroying its utility. To solve this, practitioners use a strategy called offsetting. Offsetting is the process of trading distinct asset classes against each other. It allows the parties to achieve overall value parity without having to liquidate the underlying assets. In a classic example, one spouse retains their entire pension intact. In exchange, the other spouse receives a correspondingly larger share of the available cash equity in the family home. The physical assets are unequal, but the macroeconomic balance is fair. The legal driver behind the heavy use of offsetting is found in Section 25A of the Act. This section contains the clean break principle. It places a statutory duty on the court to consider terminating all financial obligations between the parties, such as ongoing spousal maintenance, as soon as it is just and reasonable to do so. Offsetting is the master strategy because it simultaneously satisfies the immediate housing and retirement needs of both parties, while engineering the clean break the law demands. Securing financial remedies on divorce is a delicate macroeconomic balancing act. The practitioner's workflow is strict. Take the inventory under Section 25, apply the principles, prioritizing needs over sharing, and execute the settlement using statutory tools like offsetting. The yardstick of equality is the starting line for negotiations, not the finish line. Literal, line-item equality remains secondary to establishing functional financial independence and securing the welfare of the children. A legal professional's true value lies in navigating this complex discretionary architecture to build a structurally sound settlement. Applying these rules correctly minimizes court intervention, keeping negotiations productive and protecting the family's remaining wealth from being drained by litigation costs. Ultimately, the objective of the Matrimonial Causes Act is not to simply divide the past. It is to lay a viable, equitable foundation for two independent financial futures.